4058 JP Morgan Chase Bank versus Arnold Chavez appearances.
Buckle up, folks. Today's case is a masterclass in courtroom chaos. JP Morgan Chase versus Arnold Chavez, a credit card debt dispute that spirals into sovereign citizen theatrics. Chavez isn't just disputing the debt, he's rewriting financial law on the fly, demanding internal bank records like he's auditing Wall Street. Spoiler, the judge isn't buying it. Will Chavez's cash equivalent theory hold up? Or will this end in a legal faceplant? Let's dive in.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared, and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent, I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm...
No, we had a hearing on, maybe. I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
What is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, you know, I've been researching the law and, you know, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure, and you know, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, you know, based off the accounting, that I am paying what I'm supposed to be paying.
Here's where Chavez's argument implodes. He claims the bank owes him money because his credit application was a cash equivalent, a classic sovereign citizen myth. The judge shuts it down hard. You used the card, you didn't pay. That's the issue. It's a brutal reminder. Courts deal in facts, not fringe theories. But Chavez isn't done yet. When the lawyer admits he missed the filing deadline, the judge sets a new hearing date. Notice how Chavez suddenly goes quiet. Even he knows this train's headed one way.
And based off of what they're saying,
your last payment, I mean, back on 5/15/23, you owed $3,398.36. And they're coming for $3,398.36. I mean, that was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You know, you say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is, which I'm entitled to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card, and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. One second here. I have them.
No, wait a minute. December 19th, there's a problem.
Okay. It's going to have to be January 9th.
Okay.
My clerk's indicating.
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition. Hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
Here it comes.
Bill,
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674, the Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for inconvenience, so that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So, here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to...
The judge.
I'm setting a date. So what, do we need discovery on this? Mr. Goethals, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands?
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached. That the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want
Defense to this claim, and
I couldn't even enter any evidence.
and a judgment in the amount of what is claimed in the complaint, $4,378.29 will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that. Mr. Arnold, I have ruled against you. I am allowed to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it.
Yeah. Oh. Okay. Are you Sherman Moore?
I am not.
You're not. Okay. And so are you appearing on Mr. Moore's behalf?
Yes.
Okay.
I am yes, here for that matter to handle the matter that's at hand.
Okay. And are you an attorney, sir?
I am the attorney, in fact, for the said name at hand here.
Okay, so you are an attorney representing Sherman Moore?
Yes, I will be handling the case for Mr. Moore.
Okay. And are you licensed by the state of Washington to practice as an attorney?
I am not licensed or a bar member or a lawyer or anything of the such, but I am here as a beneficiary.
Before I respond, let me see if the city takes any position. Mr. Gunderson, is the city taking any position on the representation of Mr. Moore in this matter? I don't even know if you're appearing on behalf of the city in this matter.
Good morning, Your Honor. Will Gunderson, prosecuting for the city. Your Honor, the city does typically appear for the contested hearings in which officers have been subpoenaed.
Was an officer subpoenaed in this matter?
Yes. Your Honor, the officer is present. Officer Berglund is here. Your Honor, my position at this point is to request a short continuance in this case. The basis being I rely on the Judicial Information System, or JABS, review that information relevant to the particular case. Within the last 20 minutes, the JABS database has gone down. Oh.
And do you take a position on the representative of Mr. Moore appearing in his stead this morning for purposes of the hearing?
Your Honor, ultimately, the city would defer to the court on whether or not the individual is present is allowed to act on behalf of the defendant. To cut to the chase, Your Honor, this sounds like it might be a sovereign citizen type of situation. I don't know if the individual that is seated here is in fact the defendant, or if he is a completely separate person. separate and apart from the defendant that was pulled over at the time this incident took place. So that is a red flag, so to speak, or a question mark that does get raised in the city's mind, for which the city does believe that a further inquiry by the court may be appropriate. But ultimately, Your Honor, with regards to any representation, city will defer to the court.
All right. Thank you, Mr. Gunderson. So, sir, I'm going to ask you to identify yourself for the record, please.
I am one of the people.
I'm sorry?
One of the people.
Okay. Are you or have you been previously named or identified by the state of Washington as Sherman Moore?
I am not Sherman Moore,
Okay.
the entity in which you speak of.
Okay. And do you have any relationship to Sherman Moore?
I am just a beneficiary.
Here is that at this point, based upon the record that I have before me, sir, you are not authorized to represent Mr. Moore as an attorney in this matter because you are not a licensed attorney by the state of Washington. And at this point in time, based on the record, Mr. Moore has not appeared in.
Oh, he's right here, sir. Sherman Moore is right here. The name in which you speak, he is right here, sir.
Well, that, for the record, you're holding up a piece of paper.
Yes, the document, Sherman Moore, the entity in which you speak of, and one in which you tend, or this court intends to charge. So I am just a beneficiary of said entity. That is all. And that's why I'm here. So basically, I'm trying to find out the nature of said charges that pertain to said name.
Sure, certainly.
Is this a criminal or a civil matter is what I'm trying to figure out here, sir.
This is a civil matter. So Sherman Moore, or an individual identified as Sherman Moore, was issued an infraction here in the city of Lakewood on September 5th, 2024, and was ordered to respond to the issuance of that infraction, which it appears that he did, and requested a contested hearing in which he is asking to challenge the evidentiary sufficiency of the information relied upon by the issuing officer who issued the infractions for the issuance of those infractions. But by requesting that hearing, Mr. Moore, or the individual who was issued the infraction named Sherman Moore, indicated that he would appear in person as a living person here in court. And the problem that I have at this point in time is that based upon the record that I have before the court, Mr. Moore has not appeared as a living, breathing human being in this court in response to his request for a hearing.
I am simply just a man on the land that is here on behalf of that name as the beneficiary for that name.
I understand that. But at this point,
There's a claim being made. So therefore, like I said, I'm just here to understand the nature. You say it's a civil. So where is the verified complainant for said charge?
complainant is the city of Lakewood, represented by the attorney on behalf of the city, who is seated in the courtroom to your left, appearing down to my right. And Mr. Gunderson, I'm just going to ask you to formally identify yourself for the record.
Thank you, Your Honor. Will Gunderson, prosecuting for the city. I am licensed to practice law in the state of Washington. My bar number is 46991.
So the plaintiff in this case is the city of Lakewood. They are appearing here this morning through counsel, or this afternoon through counsel. It also appears that the officer who issued the infraction to Mr. Moore is also present in court in response to the subpoena that was issued for his appearance. It appears that the only individual who has failed to appear for this hearing is the respondent, Sherman Moore. And so at this point in time, with the matter having been on the calendar at 10:30 a.m., it's now 12:04 p.m. Given that Mr. Sherman Moore has not appeared in person for this hearing, pursuant to the rules for infractions in Washington courts, the court will find that Mr. Moore has failed to appear and will enter a finding of committed to each of the 5 infractions. And I believe that concludes our court's calendar for today. So thank you all very much. At this point in time, the court will be at recess.
Understood, Judge.
Oh, yeah, I'll do it in the, yeah.
All right.
In the end, Chavez's legal Hail Marys crash and burn. The judge rules decisively. He took the money. He owes the money. No amount of pseudo-financial jargon changes that. And in a poetic twist, Chavez repeats the same script in his next case. Against Discover Bank, same excuses, same outcome. If this felt like déjà vu, hit like for the judges who keep sovereign nonsense in check. Drop a comment. Should courts humor these arguments or shut them down faster? And subscribe for more. Courtroom drama where logic always wins.